Hello, I'm Henry Quillian. I'm here at Taylor English Duma in Atlanta with my colleagues from both the litigation department and the corporate and transactional department. Today we're going to be talking about crafting arbitration agreements. For those of you out there in the world, we are not providing specific legal advice. We are discussing topics that are important these days and things that impact your litigation or your dispute resolution processes. There are a lot of cases that go on, or disputes that arise regarding arbitration agreements, which are very frequently put into all sorts of contracts, including construction contracts, software development, employment contracts, contracts between corporations when they're being bought and sold, any sort of contract that might result in a need for a dispute resolution. There are other contracts that have somewhat similar type provisions, such as insurance policies that have appraisal clauses and other ways of contractually directing dispute resolution to another forum, a forum other than court. My colleagues will be asking questions and commenting, and in many instances I'll need to repeat what is being said so that those on the video can hear and possibly other people in the room. So today we're discussing crafting arbitration agreements with a goal toward getting something that is good for our clients so that when they ultimately get into a dispute, they're not just mad at us for what we did when we drafted a contract for them. We want to make them glad and not mad. We're going to discuss who the parties are to the arbitration agreement. That could include potential of combining arbitration between the people that are directly entering into a singular contract with other parties like third parties that may get involved in the same dispute and have critical information and or have where they're clearly going to be claims over against third parties for problems such as on a construction project where the general contractor wants to bring in the subcontractor that did the work into a singular dispute resolution forum. We're going to discuss how many parties we would want to have involved, how much money is likely at stake, because that drives what kind of dispute resolution do you want to have. Do you want to have arbitration at all, or do you just want to have a required meeting and I don't know, rock, paper, scissors or something to resolve the dispute as opposed to paying an arbitrator to do it or going to court? One of the touted reasons for arbitration, and that could be the subject, whether or not arbitration is good or bad could be a subject matter of an entirely different discussion. I think it has been. I think we have a litigation fundamentals with Henry Quillian on that, is whether speed of resolution is the most important thing. And if it is, what sort of provisions do you want to put in your arbitration agreement that guarantee that the result should come out fast as opposed to have, for instance, a lawsuit that goes on for years and years. And then also, is likely that whatever arises out of this contract, is it likely to be a bet the company situation that's going to be devastating to your company if you have a bad result where there's going to be very limited appeal opportunities, or is it just getting the matter over with and decided so people can move on with their life? Will the parties likely have any money to fund an arbitration? Because in many instances, arbitration costs a lot of money up front, and then you have to pay along the way. And in most arbitration forum, they actually say you have to pay them in full before they'll issue an award. If parties can't come up with the money, that puts a party that wants an outcome to be known in a position of possibly paying for the other side in order to get the award that they want, to be issued. So, because arbitrators, that's a principal way of getting paid is making sure they won't give you a decision until they get paid. How are these arbitrators going to be selected? How many of them are there going to be? Are there going to be any appeal rights, which we'll go into substantially later? and then what rules are going to apply. So we're now going to page 3 for those on the website. So for those from the 1970s, y'all may know that when somebody said something super bad, that actually meant it was really good. But what we don't want is super bad arbitration clauses, especially if we're the drafters of them. If we're litigators, it might be the best thing known to man for business, because you got a dispute that you got to resolve, even as to how you're going to resolve the dispute. But as people drafting contracts, we don't want a circumstance where our clients are saying, how did you possibly get me into this crazy situation where things are in really bad shape? So I'll point out one of the worst arbitration clauses I've ever litigated. And this is a home construction dispute. The parties didn't even sign the contract that was ultimately found to have the binding arbitration clause. The parties were sharing documents back and forth that had arbitration clauses in them, and they couldn't decide how they actually wanted to do the pricing on the project, whether they wanted it to be a fixed price or whether they wanted a cost plus a fee. And they just started performing under and paying under a contract other than the one that had this arbitration clause. But one of the things you will find out is that courts very much like arbitration clauses, and if they can come up with any excuse to send a matter to arbitration, they tend to want to do that because that gets it off of their plate. Well, this clause, example-wise, says any and all disputes arising out of or in connection with this agreement shall be arbitrated by architect John Smith in Atlanta. Well, what immediately comes to mind about the person that was designated to arbitrate this? What is his name? Is it very unique? No. And it was John Smith in Atlanta, or the arbitration supposed to be in Atlanta? Well, what if the parties don't even know who John Smith is, which they didn't in our instance? And what if John Smith has no idea that anybody signed this contract that's appointing him as arbitrator? Which he hadn't. He didn't. It was because it was in a contract that was not fully baked, but nevertheless the court sent it to arbitration. So we have a situation where nobody knows who the arbitrator actually is. Nobody actually knows what's supposed to be arbitrated and where it's supposed to be. And are there any rules that say how this is supposed to go about? If we actually knew who John Smith was, then we don't have any game plan for John Smith to follow. There's no rules referenced. Is John Smith even qualified? If he's an architect, does he actually know anything about the subject matter other than generalizations about the dispute between the parties? So essentially, in our instance, the court just said the parties must go arbitrate. It took probably 3 months for us to agree to an arbitrator because there was no forum listed, there were no rules listed. We agreed to the arbitrator, and then the arbitrator just had to make up everything that he thought was appropriate for the arbitration. And the parties, of course, were already at each other's throats, so that made everything that the other party suggested to be very suspect. And so trying to get agreements on all these matters was difficult. We're now going to page 5. So, likewise, you can have an arbitration clause that's totally not fitting for the dispute. Let's just throw it out there. What would y'all say the average per hour cost of an arbitrator is in Atlanta if it's somebody with a reasonable amount of experience?
400.
All right, 400, 450 an hour. And how many days, even if you have the simplest arbitration, is a dispute likely to take if you include any preliminary matters, an actual hearing, and then an award?
Never have less than 2.
All right, never less than 2, but that included preliminary matters and?
Oh, no. That's just the
okay.
hearing.
So let's say you have 4 days minimum invested by an arbitrator. What if you have this particular clause for those on the video, any and all disputes arising out of or in connection with this agreement shall be arbitrated by a panel of 3 arbitrators. Each party shall appoint an arbitrator, and those 2 arbitrators shall pick the 3rd. So here you've automatically got a situation where you have what's called advocate arbitrators or selected arbitrators, where each side gets somebody they hope will vote for them, which is, some people think it's great, some people think it's bad. Again, it's a topic for another day. And then those 2 pick a 3rd with no specific criteria. What if they pick somebody that's $1,000 an hour? Who's going to tell them what to do because they don't know what they're doing? Maybe it's the dentist and the garbage man that have to pick the 3rd person who actually knows the subject matter of the arbitration. And then, what is this? Just it's a $10,000 dispute, and the parties need to have 3 arbitrators at $450 to $600 an hour deciding this matter. Who's going to be happy if the client, if you're the one that drafted that contract for your client and it's just a contract relating to a small, let's say, building of a deck on the back of the house or something? Nobody's going to be happy. So, and are these arbitrators going to have any specific qualifications? Who knows? Maybe they don't have any idea how to run a hearing. Maybe they don't have any idea what the subject matter is of the arbitration. So, and there's no statement in this arbitration agreement regarding how they reach their decisions. Does it have to be unanimous? Can it just be 2 out of 3 that vote in favor? Now, oftentimes a clause will have more in there if you've taken it out of a form book, and it may have that type of information, but then again, it might not. It's all up to the people drafting the contract, and lots of times I've seen it where clients will literally, as crazy as it may be, just staple pages from various contracts together. No, we need one with an arbitration clause. Let's just staple this page on to the contract. And so you end up with a mess that can result in huge disputes just over how you're going to resolve the dispute. Okay, so how do we make an agreement that works for your client? We went through the basic questions earlier on about provisions that would be helpful, or things that would be helpful in determining whether you've got the right dispute resolution clause for the specific contract. You know, how much is involved? How critical will it be if there's a wrong decision? How fast do you have to get to the decision? How binding do you want the decision to be? We're now on page 7. And so how many of y'all have been involved, and I'm sure everybody has been involved somewhere or other with the American Arbitration Association? Okay, every single person in the room. The American Arbitration Association was the was one of the earliest, I should say, big organizations to heavily market and try to get its contractual clauses for arbitration into a whole lot of contracts. In the construction arena, there are a whole bunch of standard forms that contain what we'll call AAA arbitration agreements, and then they also have them under commercial arbitration rules and a whole lot of different deal documents for all sorts of different disputes. And they issue rules which are very organized and which lay out the rules of the road for appointment of an arbitrator, which is a very good thing. Rules of the road for when arbitrations are supposed to take place, what's supposed to take place before the actual hearing day, options available for the parties to pursue during the course of getting prepared for the hearing, when the awards to be issued, and how much you have to pay. And how much you have to pay is a whole lot along the way. There's big filing fees, there's big deposits for there's big deposits for fees, and then also there's administrators you pay along the way. So all of a sudden, so in this instance, we have a lot of what might need to be done in order to actually get the parties from the beginning of a dispute to the end if they want to pursue arbitration. The way they typically determine who the arbitrator would be is, our arbitrators, is based on the size of the claim. And so if you have a claim that's less than a certain amount of money, a single arbitrator will be assigned, but that arbitrator is assigned because they issued lists of arbitrators that have the general subject matter knowledge of the designated arbitration, and then the parties strike off, sort of like you would strike a jury. You strike off arbitrators that are not acceptable, and then there's a list left, and then the AAA chooses the one that's they say is going to be your arbitrator for the matter. And it all can work really well. It's just that there's sometimes I've run across deterrents when people don't want to pay a huge file. So let's say they claim they have a really big claim, and there's a possibility of them getting a very large award, but it's not necessarily a probability. But they want to claim the large amount, and if you claim a whole large amount, then you can throw your arbitration into having a really big filing fee, possibly the appointment of 3 arbitrators, and so your expenses can run up really fast, even though the claim might not be as big as you hope it is. Yes, ma'am?
I have a question. So I guess before you even draft the arbitration clause, should there be a discussion with your client as to whether or not arbitration is right for you? Number one, does confidentiality matter? Number two, the cost associated with arbitration versus going to court. Number three, what industry are you in? What's the risk of getting a judge who doesn't know anything about your subject matter? And if they don't know anything about your subject matter, how could that help or hurt you? So should there be a conversation to discuss that before you just kind of throw in an arbitration clause?
Okay, Ms. Mark asks a fundamental question that goes back to helping decide on whether arbitration is even something that should be considered by you for purposes of your client's contract. And I'm hugely in favor of discussing the dispute resolution clauses with my client as part of negotiating a contract. Regardless, if I have that opportunity, you definitely ought to discuss it. And just for the video, because of talent, she mentions the possibility of, in arbitration, of confidentiality, which you don't have in litigation, and certainly not with respect to anything that's heard at hearing or tried before a jury, unless it's just extraordinary circumstances. And then you also have the costs associated, and all that goes into whether arbitration is good or not for a particular circumstance. But you can also have elections that your client might be able to put into their contract, such as quite a number of my general contractor clients will have a clause that says, and of course they issue the subcontracts to all the subcontractors, and they hope to get the subcontractors to sign the contracts that they issue for a project, so the subcontracts will be relatively uniform throughout the entire project. And they have clauses that say, in the sole discretion of the general contractor, the general contractor can elect to either arbitrate or litigate a dispute. And so within a certain number of days after the dispute arises, the general contractor can say, well, we're going to litigate this one, and the subcontractor has no say to throw it into arbitration. And then vice versa, the arbitrator could, if the subcontractor starts an arbitration and the general contractor wants to litigate, they can throw it. They can say, well, we elect to litigate, and move to stay the arbitration. Julian, you had a question?
Yes, excuse me if you already explained this rightly, but what is the difference between arbitration and mediation?
Okay, I'm going to be very brief on this, but the question is, what's the difference between arbitration and mediation? The mediation is nothing more than utilizing a professional, third-party, neutral, to help the parties reach a settlement agreement. It does have bells and whistles associated with confidentiality and keeping what happens in the mediation out of the public sphere and also out of the evidence sphere for a court or other dispute resolution procedure. But ultimately, for mediation, the parties have to reach a settlement for anything to come of it, or a partial settlement. Arbitration literally is like hiring a private judge who is, as we'll discuss later on, can well end up being the czar of the dispute, who has final decision on everything, and they will issue a written award which is then enforceable in court. And there's not a whole lot you can do about it. Very limited appeal rights. So you're essentially hiring a private judge.
So if it's binding arbitration, that's final and conclusive. Is non-binding arbitration the same as mediation?
All right, the question is non-binding arbitration the same as mediation? No. Non-binding arbitration, and there was, for a long time in Fulton County, there was a very good example of that, where lawyers would, I don't know if they volunteered their time or whether they got paid some very modest amount, but courts would send the case to non-binding arbitration, and lawyers would come hear the case and then just issue what they think should be the outcome. It would be very, very condensed. It'd be like an argument by one lawyer, an argument by another lawyer, and then the lawyer that was hearing it as a non-binding arbitrator would just issue an award and say, this is what I think the outcome should be. And the parties would have a limited period of time, I think 10 days or 14 days or something, to say, no, we don't like that outcome. And if neither party objected to the outcome, that would become the judgment of the court. But non-binding arbitration is literally just getting a theoretically seasoned person to listen to the dispute, issue an award, and then see if the parties if their light bulb turns on based on what the arbitrator says, that causes the dispute to come to an end. So what we are talking about here, and it seems to be rare these days that you see arbitration clauses that call for non-binding arbitration. There are a whole bunch of options people can write up for resolution of disputes in big commercial projects and such, but we're talking about here arbitration that's going to result in an award that the courts will say, thank you for doing all this work for me. I'm going to enforce exactly what you say has to be done, Mr. Arbitrator. So that's going to be the outcome of an arbitration. So with respect to what we have on the screen, page 7, one of the wonderful things that these parties have done, if they were to enter into this agreement, and it's likely to have other provisions, if they've designated what the rules are, presumably they'll either be obvious where this arbitration should be held. The AAA has offices all over the place. But let's say it's a dispute between Georgians and Atlanta. Chances are it's going to go to the Atlanta office of the American Arbitration Association. And the rules, if people pay in all their money and do all the things they're supposed to do, will result, and people present their cases, it will result in an arbitration award at the end of the day, fairly efficiently, and meaning efficient in the standpoint of time, assuming the arbitrator's not lackadaisical and the parties don't ask for constant continuances and all that, and it'll result in an award. Well, will the award be reasonable compared to the costs incurred? Will it'll end the dispute, but the question, will the parties be bankrupt at the end? It's hard to say. So, what can a party do to control the process even more? Do they want to go ahead and make decisions up front by negotiation that will crunch the arbitration process and make it less like litigation and more like a very efficient dispute resolution procedure that will ultimately result in a final and binding conclusion. And so one of the things you can do, the arbitration rules in most forum, which there are a whole bunch of them these days, basically any organization that does mediation usually offers arbitration also. And most of them have rules. The rules are different per forum. So if you ever run across, if somebody walks in and says, I got a dispute and a specific forum is listed, one of the first things you got to do is go read the rules for that forum, because the rules might be really good for you, they might be really bad. And since it's an agreement between the parties, you can always negotiate, if you can get the other side to play ball, a different forum if the forum doesn't work for the dispute that's at hand. For instance, if every arbitrator is $1,000 per hour at this forum and you've got a $25,000 dispute, you might really want to go see if you can go to a different forum. You know, hire an individual, agree upon some individual who doesn't have all the overhead of the forum to decide the dispute, if you can get the parties to agree to it and amend their agreement. But one of the things you can do here is you can try to come up with, using your best guru hat, figure out how much discovery is actually going to be needed for the types of disputes that are likely to arise out of the agreement at hand. And generally speaking, arbitrators who are bound to honor the contract between the parties will honor these limitations unless the parties agree to something else along the way because they realize they botched it. They didn't put in the right numbers. And the parties can agree, the arbitrator will likely go with what the arbitrators agree. So one thing to think about is, how many depositions? Well, will a 30B6 deposition or something equivalent, the representative deposition of an entity, will that actually solve a lot of the discovery needs of the party if the party has also gotten documents that are adequate to prepare to take the deposition of that representative? If there's some interrogatories that are available, will sworn interrogatory responses either before or after the limited number of depositions get the parties to the place where they can actually go do the hearing and have enough information to either present their case or to cross-examine the other side in order to get to, before the arbitrator, at least most of the important facts associated with the case. And I didn't put requests for admissions in here, but I've recently actually had an arbitration where requests for admissions were allowed. They were served by us, and one of the parties just didn't respond to the request for admissions, and that resulted in all sorts of questions about what is the remedy, since there are no, in this particular instance, there were no set rules of how do you go about compelling answers to the discovery. Are requests for admissions deemed to be admitted if there's no response? The arbitrator did say, and it was this will give you an example of an accelerated procedure. They said because, well, we were representing the claimant, and we knew the other side had one asset, and it was a mansion that was for sale. And we wanted to get through our arbitration early enough for the other side to have an award against it before they sold the mansion. And because we knew once the mansion money got distributed, it might be very hard to get anywhere. So we asked for super accelerated discovery, and the arbitrator, I think, had a 10-day turnaround on all discovery. And but one party didn't respond to the request for admission, so we just argued basically the equivalent Georgia civil practice rules and federal rules of civil procedure to say this is what happens if somebody doesn't respond to requests for admissions. No default judgment or summary judgment was entered, but I think the arbitrator deferred the decision on exactly how these admissions were going to be treated until later down the road. But think about what you're, yes, sir.
Henry, when there are provisions in the contract that, for instance, if there were a provision that says parties will be limited to 10 depositions, but the parties may request additional, may request of the arbitrator additional depositions or interrogatories or whatever. Are the arbitrators typically willing to, participate in that we'll call it pre-arbitration process? If the contract provides that the arbitrator is going to have discretion to modify the agreement, are the arbitrators generally willing to participate to do that?
Okay, so the question is whether if you have some sort of pre-hearing discovery plan laid out in the contract, are arbitrators generally willing to participate in carrying out their role as the arbitrator and or changing at their discretion some of the agreements earlier made by the parties. And in your example, there's actually a clause that says, however, upon motion, a party may seek additional discovery or something like that. A couple of things to keep in mind with respect to arbitrators. Arbitrators generally make money by the hour. Arbitrators are called upon to make difficult decisions on behalf of other people who are paying them. Difficult decisions take time sometimes, and so arbitrators make more money the more decisions you throw out in front of them to be made because they charge per hour. And so if the contract expressly has limitations in it and there is no opening for discretion, I think you can ask, and an arbitrator probably may have the power to jimmy the rules a little bit. But if it, as in your example, if it actually expressly says, however, or provided, however, the arbitrator may, upon motion and sufficient evidence, grant additional discovery rights or something of that nature, then the arbitrators are more than happy to look at that. Now, one thing that probably a lot of y'all know, people out in the world may not know, is discovery is not a given in arbitration. I have had arbitrations where I was representing a client that didn't have many funds, and it was a fairly simple matter. I think it was a matter of whether they were going to get paid on invoices they had submitted. And I went before the arbitrator and just said, hey, this is arbitration. There's nothing said about any sort of discovery. I think that by the time we get done with doing discovery, we'll have wasted all the money we're supposed to try to collect out of this arbitration. And the arbitrator said, well, okay, no discovery whatsoever in this arbitration. And the other side ultimately didn't push back on that. The knee-jerk reaction of every lawyer is, I want to know everything I can about the other side's case. I get paid by the hour, so I want to do as much work as I can. But in reality, sometimes you just got to say no, and the arbitrator may agree with you and say, no, we're not going to do any discovery because y'all didn't agree to in advance, the rules don't provide for it, and I'm not just going to make up things and force you to go through procedures that are not expressly called for or allowed.
You also have to consider whether you're going to need third-party discovery, and subpoenaing documents is a lot harder and more complex than arbitration, if you can even get it at all.
Okay, so Mr. Jones points out that a lot of times you need information from third parties, meaning people that aren't parties to the arbitration. And the Georgia Arbitration Act, as well as the Federal Arbitration Act, does provide for arbitrators to be able to issue subpoenas. Now, I think at the end of the day, the subpoenas are definitely enforceable for the hearing to bring people that otherwise they might be, a court in the jurisdiction might be empowered to bring somebody into the hearing. I think, Oscar, I'd love your comments on this. It's not plenary. Nobody quite knows exactly the power in a particular forum under a particular arbitration act of an arbitrator to to compel a party to respond to subpoenas, except that I think you have to do it through court after the arbitrator has already issued them.
Well, I think you can get a subpoena that requires the out-of-state party to sit for discovery. But I think it's difficult to get a subpoena from an arbitrator to make an out-of-state party actually come to the hearing. So if you want to get your third-party witness, you're going to have to get it through a deposition normally.
Right, and you would have to do it, I think everybody heard that.
Yeah.
You'd also have to do it possibly through a commissioning procedure or through having a federal court issue.
Yeah, the arbitrator there are forms for subpoenas that an arbitrator can issue. You go, if you're AAA, you can go to the website. So you get one of these form subpoenas, you ask the arbitrator to issue it. The other side says, no, that's not enough, I want to get to court, and you go down and get to court and do it. But once the arbitrator issues a subpoena, the other side normally will not go through that extra step.
Mm-hmm.
I don't believe you can bring an out-of-state guy, or out-of-jurisdiction guy, to the actual hearing.
Okay, just for the video, and then I get to David. It seems to be the correct thing that you can't just subpoena people that from out of state to come to a hearing to an arbitration in your state when very potentially the court, if a court was hearing the matter, they couldn't do that either. So, but by deposition, you can do that. However, what does any kind of subpoena rely upon if you're going to get deposition from a third party? Well, what if the third party just says, no, I'm not going to do any, thanks for the paper, but I'm not going to do anything with this paper. And so that requires the additional step of getting a court in the jurisdiction where the party is to enforce the subpoena. And even everybody that litigates know that not everybody shows up that gets subpoenaed by a court in their jurisdiction. And so then you'd have to go into the contempt powers of the court. So it's not necessarily an easy process, and certainly don't wait to the last minute if you're going to try to accomplish that. Yes, David?
Just to follow up on waiting for the last minute, if you have time limits on when the arbitration is supposed to occur, most of the time you will have trouble getting a subpoena from an arbitrator if they consider that it will either push the time, the hearing date off, or that you can't get the discovery in time for the hearing date.
Mm-hmm.
So you'd better not just worry about getting a subpoena out, you better worry about the time limits and the relevance of the discovery in the mind of the arbitrator and the importance of it.
Mm. Okay, so Mr. Forstner makes the point that the arbitrator doesn't want the discovery to wag the tail of the dog. So to wag the dog, I guess I'll put it to be the tail that wags the dog, because the arbitrator may not find that whatever you're looking for is as important as he may think. You may think he should think it is. That is something that needs to be talked about, which is if you are a party and you're before an arbitrator, let's say for the moment it's a single arbitrator, not where you got to choose one and the other side got to choose one. Who do you not want to tick off in the pre-hearing procedures? Yeah, the arbitrator, because in this instance, the arbitrator is, like I said, it's like the czar of the dispute. The arbitrator gets to decide everything. And in the one that I had where a party was not participating in the arbitration, so to speak, by providing discovery responses, etc., the arbitrator just kept saying, I'm going to take that all into account at the end of the day, or if if all of a sudden a bunch of documents that were asked for show up at the hearing, I just might not look at any of those. Yeah, and that would be the type of conclusion that an arbitrator could reach if the arbitrator's orders and mandates haven't been complied with along the way by a party. So, discovery can be controlled. There can be questions that are open regarding what powers the arbitrator has to enforce that discovery at the end of the day. And if it's third party, the arbitrator is likely to be less, going to blame a party less if the third party who is somehow associated with one of the parties just doesn't comply than if a party themselves doesn't comply. And like I said, if the party themselves just doesn't give up the documents that are requested in a request for production and then shows up with all those documents at the hearing, they better have a pretty good argument as to why they couldn't obtain those documents and provide them to the other side earlier. Okay. Dispositive motions. So for those that aren't lawyers, a dispositive motion is a motion or a request that can be made to a decision maker that can put an end to either the entire dispute at hand or some portion of the dispute and make it a final conclusion. So we talk about in litigation motions for summary judgment, sometimes motions to dismiss with prejudice. But arbitration doesn't really necessarily provide for any sort of decision by dispositive motion. It depends on the rules of the forum that's at hand. And the rules, how did we talk about arbitrators making money? All right, time. And generally speaking, how do the companies that provide arbitration services to others make money?
Size of the claim.
Oh, the size of the claim and a portion of the arbitrator's fee, usually, right? And do hearings take longer, or does deciding things on paper take longer? Most of the time. Hearings take longer. And so, arbitrators might tend to want to not decide things by dispositive motion, but they might want to if it's going to be a ridiculously long hearing over something they pretty darn sure they know the answer to once the parties present it to them, then they might just want to go ahead and get rid of that question. And by the way, everything I'm saying here is a little bit tongue-in-cheek because I think most arbitrators actually want to gain the reputation of getting a matter resolved as quickly and as efficiently as possible and to put matters to rest. So yes, if the parties actually expressly provide for dispositive motions, that will greatly enhance the probability that an arbitrator would be willing to take one issue or more issues than just one based on some affidavits and briefing and come to a conclusion, issue an award on that particular issue. And sometimes that can wipe out so much of the case the parties will go ahead and settle the rest. Sometimes it'll make such a huge impact that the dispute will come to a conclusion quickly. Now, the question is there a litmus test that the parties have to meet before a dispositive motion will be heard? Or alternatively, can you put something in the arbitration agreement that says, hey, if you, being a party to this arbitration, runs the arbitrator around trying to get a dispositive order issued and you lose, should you have to pay for that whole endeavor, or should there be some other sanction that results in you causing all this expense to the parties? So one way that can be done is by allocation of the arbitration costs at the end of the day. If the arbitrator thinks one side has just caused a whole lot of hassle and a whole lot of expenditure of time that never came to anything, the arbitrator can allocate the arbitration costs against the party that caused all that. But also theoretically, you could put in your agreement, and I think that's probably the only way it would come about. In fact, I've seen that recently, that if somebody pursues a particular course of action, it ends up being unsuccessful, the arbitrator can levy attorney's fees against the party that pursued the unsuccessful effort. And here we have an example on page 10 of the litmus test that must be pursued if one is to try to seek a dispositive motion under the AAA commercial arbitration rules. As I mentioned, we've given an example of a construction industry arbitration rules, and then there's a separate set of rules that are similar but different for commercial arbitration. So even if you're an arbitrator, you better read your rules, because it's not going to be the same just because it's a AAA. The arbitrator may allow the filing and make rulings upon a dispositive motion only if the arbitrator determines that the moving party has shown that the motion is likely to succeed and dispose of or narrow the issues of the case. So, what does that mean has to happen?
Sounds like that's a TRO hearing.
It's sort of like a preliminary, but it's often a motion to file a motion.
Yeah.
You know, is that Oscar? You were.
I was going to say that's usually, if you've got a statute of limitations, which would knock the whole claim out, or if you've got a jurisdictional issue. So you file a motion under Rule 33 that says you don't need to go any further. You have no jurisdiction over this matter. Dismiss it.
Okay. So it could be a jurisdictional matter, statute of limitations, or something else that would be an example of one that knocks out the entire claim. But otherwise, for instance, I suppose in order to file let's say you're just suing on invoices or arbitrating on invoices, and you file an affidavit saying, I did the work, I submitted the invoices, never heard from anybody from the other side for 6 months, and as soon as I demanded arbitration, they denied ever having gotten the invoices, or they denied ever owing a penny on the invoices. You might be able to then get the arbitrator to say, well, I just need to hear this by summary judgment, because if they didn't say anything for 6 months after we submitted the invoices, then chances are they owed the money. They're just making up excuses for not wanting to pay. Something along those lines. But one way or another, it's a two-step process. So if you're in an arbitration, don't just file a motion for summary judgment. You better read the rules, determine whether you got to ask permission to file the motion for summary judgment, and then have your motion ready to go if the arbitrator says, sure, we'll go ahead and take this one on summary judgment. Okay, a little bit more dicey issue. Appeal rights for errors of law. Frankly, I hadn't actually run across the proposition for this until relatively recently. You can put into your arbitration clause an opportunity after the award is issued for you to try to attack the law that was applied or the application of the law by the arbitrator in the award. In order to do that, what kind of award would you have to have? Okay, Mr. Carter has said it, a reasoned award, meaning one that actually explains why the arbitrator is reaching the decision. Something we didn't actually discuss earlier. If you don't call for a reasoned award, an arbitrator can just issue an award that says, Jim must pay Sally $5 million, and that's the entire award. That's all it has to say. But if a reasoned award is required, it would have to say why Jim has to pay Sally the $5 million, what the basis of the facts would be, what the law would be. It doesn't have to have every single possible fact mentioned, et cetera, but it has to be reasoned. But let's assume that there's some cutting edge area of the law or something that's where the parties believe it's as much a legal dispute as it is a factual dispute, and the arbitrator is believed by one party to have gotten it completely wrong based on a Supreme Court decision and the state that's controlling. Now, I'm not going to go into it, but except for to say, generally speaking, there are extremely limited appeal rights to an arbitration award that's supposed to be final and binding. If the parties agree, it's going to be a final and binding arbitration award. The states and the Federal Arbitration Act have crunched down by statute on the ability to appeal, and the courts have construed those statutes to provide only the slightest little cracks that a party might go through to try to undo an arbitration award that has been issued. One of them is called manifest disregard of the law, which I'm not going to talk about except to say, basically that requires a reasoned award for the arbitrator to say, I know the law requires me to do this, but I'm going to do that instead, which hardly ever is the case, and so hardly ever do you succeed in getting the court to overturn it when you go to confirm your award, or when you go to attack the confirmation.
I believe there's also case law that says misapplication of the law is not manifest disregard of the law. So it's a much higher standard than it sounds.
Yeah, extremely high standard to overcome. So what I've done in this sample clause is just to throw one out there. If a party contends there is a clear error of law has been committed by the arbitrator in the award, then that error of law may be raised in the court of competent jurisdiction in blank county, I put California, and may be determined in the context of summary judgment regarding the confirmation of the award. So clear error is a standard that is recognized by courts of appeal in some scenarios. It could just be an error of law, but the question is how final do the parties want to be with respect to the final and binding decision of the arbitrator? If they want them to be super binding, then they would leave out any provision like this. If they want to have some possibility of having overturned, if, for instance, the arbitrator is contended by one party just completely botched the decision based on the law, where the law, 9 out of 10 lawyers would say the arbitrator got it wrong, then this might provide an opening. Now, I mentioned that I didn't put Georgia in there, but I'll get to that in a second. So just looking at some rules that actually exist, we're now on page 12. This is Rule 52C of the American Arbitration Association's commercial rules. And it provides, essentially in 52C, that the arbitration award is going to be final and binding against the party. But there's the possibility of preserving whatever rights there might be for appeal by suggesting that the arbitration agreement have a non-prejudice clause basically put in there with respect to errors of law, non-prejudice to your rights to appeal, which would suggest there's some opening for addressing errors of law. Or you could put that in combination with a clause such as I had on the previous page saying only clear errors of law, but then there's some sort of penalty that's associated if you go after a change and you get it wrong, so the parties aren't wasting their money on court proceedings that they attempted to avoid by arbitration. But so in California, the California courts have decided that their arbitration code is broad enough to allow parties to attack errors of law in arbitration awards if they say that the arbitrator does not have the power to go beyond the correct error of law and correct legal reasoning. And that's because arbitration comes about generally not as part of common law, but rather because of statutory provisions, either in the Federal Arbitration Act or in the State Arbitration Act. And so you could theoretically do this if you had a contract where California law applied. However, and I'll skip down 13, it just goes into that particular limitation or the reason why you can attack an arbitration award. The arbitrators aren't supposed to exceed their authority. But in Georgia, and this is page 15, the Georgia Supreme Court has held that basically there was not arbitration at common law. The Georgia Constitution likes to preserve the right to trial by jury. the Georgia Arbitration Act was passed to allow arbitration to take place. The Georgia Arbitration Act has very limited scope of appeals of arbitration awards, and so it is held that it's not possible in Georgia to expand the appellate rights of an arbitrator of a court to review an arbitrator's decision by agreement of the parties. So if you wanted to, you could put it in your agreement, even if it's agreement between people in Georgia. I would put a little note to your client saying, hey, this isn't enforceable at this time. If you get an arbitration award that's really bad for you and you have and it's because the arbitrator completely botched the law, then you have something to argue about with the other side after the arbitration award is entered. But would you go actually to court to try to get that award reversed because of the error of law? That would be a risky decision that you would have to see how the law was unfolded, what other cases have come out. Has the Brookfield Country Club case been amended over time? Okay. And then I throw in possibilities of ways of deterring people from seeking a reversal of the arbitration award by providing some sort of deterrent, like making the prevailing party, giving the prevailing party the opportunity to get attorney's fees because the other side tried to press the limits and didn't. One more thing quickly. If you've got a big set of documents that you're working with, and let's say you have a contract that has an arbitration clause, and then you have a warranty that's supposed to be required by that contract that has an arbitration clause, you better direct all your disputes to a single arbitration clause or have some really clear delineation as to when one stops and the other one takes over, because otherwise you'll end up with two different arbitration clauses potentially addressing the exact same dispute, and that does not solve problems for your client. That causes problems for your client. And in fact, I just finished an arbitration a couple of months ago where I got there because there was a declaratory judgment action, and the dispute at hand covered exactly two totally different arbitration clauses appointing two different forum, different sets of arbitrators, and the judge just said, well, you don't get either one of them, you got Quillian. So that was good for me, but it was bad because it spent time. It took probably 6 months longer for the parties to get to arbitration than they had anticipated.
And related to that, and this is especially true in construction contracts, where you're going into a situation where your client is going to have multiple contracts and maybe multiple downstream contracts. You want them all to have the same dispute resolution provision, because you can find yourself having to fight in court and in arbitration on related matters, and you can't bring them together.
Mm-hmm. And another example, this is Mr. Carter just gave one, but I had a dispute. Well, I had a provision. It was a condo developer, had everybody that bought a condo sign an arbitration agreement. But the arbitration agreement said you can only do your arbitration all by yourself against the developer. The condo association also had an arbitration clause with the developer. So when there were construction defects that were throughout the entire complex, including common property and the individual units, essentially what that did was drive there to be, let's say 50 or 60 separate arbitrations, plus the condo association's arbitration, so that each person had like a $2,000 claim. And so it made it very hard to arbitrate. In that particular instance, the developer played ball and decided to treat everybody as one and to settle it as one big group. But you can, by way of arbitration, you can divide things up into little bits and pieces and make it difficult for people to bring claims, or you can make it very hard on yourself by agreeing to a whole bunch of different forum that might end up with different outcomes. Anybody else got anything for the good of the order? Mr. Moeller does.
Question, do forms provide for arbitration, the standard
You,
forms?
you get to select. You can select litigation or arbitration. It's a checkbox on the
Do you
AIA.
have a
forms.
recommendation?
My recommendation usually depends on what my most recent experience dictates. If I want an arbitration, I go to arbitration. If I want a court, the problem in construction cases is that arbitration, generally speaking, is not any faster, and it's way more expensive than court because you're paying, the filing fees and the fee for the arbitrator and all that kind of stuff. But the good thing about arbitration is you get an arbitrator who knows construction, whereas juries don't know construction. So you only know, in my opinion, you only know looking with hindsight which was better. If you have a very technical construction defect case, you want a good construction lawyer as an arbitrator that you can argue all the minutia about the specifics of the contract or the bolts or that kind of thing. If you're representing somebody where you have a great story to tell, then you want a jury. The way you present it is it's 180 degrees different the way you present to a jury or an arbitrator. So, I give my clients, I just kind of go through the pluses and minuses of both and let them choose, for the most part.
If I had the opportunity, I'm the person that can draft the contract and force it on the other party, I put in the election so I can determine what the dispute is before I decide how I'm going to resolve it.
Yeah, if you have the ability and you're representing somebody and you have the ability to write in that your client has the sole election, then do that. But that doesn't always fly.
And David, you had something?
Yes, I think when you're drafting these clauses, you need to know the difference between what a private arbitration is and then if you want to have it confidential. Because this is not a confidential process, it's a private process. People can't walk in off the street, but that doesn't mean anybody involved can't tell anybody what they want to know about it. So that's a big difference. And a lot of people think, hey, I'm in arbitration, it's going to be a secret. It is not a secret.
Unless the parties agree.
Unless the parties agree. And if they do, then you're going to need to put some teeth in that confidentiality clause and make some kind of enforceability to those teeth. Otherwise, it's going to be meaningless.
Okay, well, it's not meaningless. I mean, the point that Mr. Forstner is making is that you can either have super confidential by agreement, strong confidentiality agreement, or it's just private. It doesn't take place in the open forum. But except for if somebody goes to court to confirm the arbitration award, it's not on the public record, which is helpful.
Yeah.
That doesn't mean it can't be found out somehow, but I don't know what the rules are if the AAA gets subpoenaed for an arbitration award. I'm not sure what their obligations are to refuse to release it.
I think that they would probably require the subpoena go to the parties.
Mm-hmm. Let them fight it out.
Yeah.
Okay, anything else? And certainly if
Perfect arbitration clause, Henry, that we transaction people can just plug in our guy.
well, that's the whole point is you got to figure out what the deal is. If you have the control over the contract and have a gazillion clauses that are in favor of your client, like some of the subcontracts I get handed to me by my subcontractor clients, you might just want to go to court because that's where you're going to get your hardcore legal, cut off at the knees type of remedy. So, but you gotta, if you really want to think about it, you need to have an arbitration clause that fits the potential disputes that arise out of the contract at hand, not just have a generic one that has all the bells and whistles, or alternatively one that has way too many arbitrators or whatever, because you'll end up with people asking you, why in the world did we do this? How are we in this situation?
It's hard to negotiate, but some of the best arbitration clauses will have stepped up provisions that say if the dispute is $20,000 or less, there will be no discovery. We're just going to tee it up and have a hearing. If it's under $100,000, there will only be one deposition per side. If it's over, stuff like that. But you have to spend a lot of time and money with a very sophisticated client with potential for all kinds of levels of disputes, and then negotiate that with everybody. So it can work and limit some of the financial exposure, but they're hard to get pushed through.
I like requiring mediation as a precondition to the filing of an arbitration, or at least a meeting between the principals of the companies or something like that, to try to limit the need to pay the huge filing fee, first of all, and then secondly, hopefully you get it worked out. Our real goal, obviously, when we're drafting contracts, is to get the disputes resolved and get them resolved at least in an acceptable way. And then if you have to go to the bat, you want to win big, but and you got to figure out where you're going to win big. Is it in arbitration or is it in litigation? So, all right. Well, thanks all for being here.